2, 3. Ok. Hello, everybody. Boa noite, Brasil. Eu vou precisar falar inglês e português, porque boa parte da nossa audiência vai ser em português. Pessoal, desculpa, não vai ter tradução simultânea, a menos que o YouTube ajude a gente, tá? Mas bem-vindos ao nosso Woman Community Prize. Welcome, people. Welcome, everybody. Our first webinar the year, Woman Community and Prize. This night, we have this greatest woman, Odia Keegan. She's a very, very busy woman, but she donates a little time for us to share with us for discuss about the international legal challenges about privacy laws, American laws, GDPR, and I'm here to make some compares with LGPD in Brazil. Odia, please introduce yourself, present yourself for our public. Pessoal, eu vou tentar traduzir para vocês em português, ok? A apresentação dela, a Odia é sócia e chairman na Foxchild Advogados, e ela vai fazer a apresentação dela, falar quem ela é, e depois a gente vai começar com as perguntas. Fiquem à vontade no chat, por favor. Please, Odia, it's your time. Please shine. Introduce yourself.
All right, thank you. Hello, everybody. I'm very happy to be here. My name is Odia Keegan. I'm a partner and chair of GDPR compliance and international privacy at Fox Rothschild. It is a national U.S. law firm. I do all types of privacy compliance, which means that I help companies structure their products and services in a way that is compliant with U.S. laws, the new U.S. laws, state laws, federal, and I also do a lot of GDPR, which is, as you all know, is similar to LGPD. So I will try to, translate where I can into concepts that you guys are more familiar with. I do a lot of content on LinkedIn, and I welcome you to connect with me, and I would be happy to hear from you and hear feedback about the presentation and questions. So thank you for having me.
Odia, I will make the question in English, and then I will make the translation for Portuguese, okay? For the people try understand, because we have some persons that is not common speaking English, but they will make your best efforts to understand our dialogue here, our webinar. So the first question, I think, so the main point here is when we talk about federal law, United States don't have a federal privacy law. Just one. You have CCPA, CCPRA, BPA, you have state laws, right? It's segregate laws. This is a challenge, right? Because each state understands privacy in one perspective. It's not a unified consensus, right? They don't have one only view. Each state have your own view about privacy for your citizens. So what do you consider in the context of United States talk about privacy? How you see this challenge, the difference between each state, the way that each state creates your regulation? Are you missing the federal law? What do you think? Pessoal, just a moment. I put the português. Pessoal, eu estou perguntando para ela qual é o que ela acha que é o grande desafio, né? Já que os Estados Unidos têm leis segregadas por estados, cada estado vê a sua legislação de uma forma para os seus cidadãos. Se ela sente falta de uma lei federal, né, unificada. Please, go ahead.
So I think it's even more complicated. We have in the US, so we do not have a comprehensive federal law like GDPR. But we have, first of all, a lot of sector specific federal laws that pre-existed even before the new laws. We have a law that talks about a certain part of health data, which is HIPAA, if you're familiar with it. We have laws that deal with financial information like banks, like Graham-Leach-Bliley, the Fair Credit Reporting Act. We have a federal law on children's information of under 13-year-olds, which is COPA. We have a lot of these federal laws. Then we have state-specific laws, and even that's really complicated. Why? Because we have, first of all, we have 50 different data breach laws, right? So each state has its own data breach law with its own definition of personal information, with its own requirements for when you need to notify, and 50 different ways of notifying. We now have 6 because the 6th law was signed by the governor today. So we have 6 state laws that are comprehensive, so are sort of GDPR-like, even though not exactly. And then we have a lot of other laws that are specific. We have, you mentioned BIPA, which is the Illinois Privacy Biometrics Privacy Act law. So that is a biometrics law in Illinois. We have one in Texas. We have AI laws. We have information security laws in 23 states. So it's really complicated because the laws, not every state has its own comprehensive law. There are pieces that are regulated by different laws, and the approaches are different. So that by itself is complicated because you need to look at each state and see what the difference is. It's also difficult to even know which laws apply to you. And then the last piece, which complicates it even more, is that the FTC, the Federal Trade Commission, which is the US federal authority that is in charge of antitrust, but also privacy, is also regulating privacy in a way. It does apply all over the US, but it regulates by way of enforcement actions, which means that you don't have one law to look to. So the bottom line here is that it is really complicated. It is difficult to keep on top of, and it is difficult for companies to do. And even more complicated is that we now have 22 states that have privacy bills submitted that have not yet been passed. So we are probably going to see additional privacy laws that are not exactly the same.
So when we compare, when you attend your clients, your customers, and they have the necessity or they have a request to stay in compliance with GDPR, but your client is on United States, but for some reason you need to put your client compliance or in compliance with GDPR. What is the most challenge? Because you don't have a federal law, so you have state laws and you have other federal laws specific, right, sectors. So what is the challenge to adequate your customers to GDPR because they have this American laws mindset? Is the different to GDPR? What is your challenge to adequate this?
So it is more difficult. We can divide this to before the new laws, before CPRA and CCPA, and after, right? After, let's start with after because it's easier. After the new laws, if you are a US-based company that is subject to CPRA, then the things that you are grappling with are, first of all, wait, I'm a small company. Why does this apply to me? Because under the US laws, unlike GDPR, it doesn't apply to everybody. You need to either be a big company with $25 million of revenue, not from the state, generally speaking, or you need to process a lot of information, like 100,000 records of people from the state, which in California is not a lot, but in Connecticut or Iowa, it's a big part. It's a serious part of the population, right? Or you can be a small company, but you monetize data, right? You sell data. GDPR applies to everybody. If you process data, it applies to you. So that's really one mind leap. The second one is the legal basis, right? Like legal basis is a big thing because we don't really have a legal basis in the laws. There are a couple that were of the bills filed that actually have legal basis as the structure, but not yet. So like those things are kind of different. Before CCPA, it was a big, and also companies that are not subject to GDPR, so to CCPA, that need to, to comply with GDPR. It is, the big thing is, what do you mean, the scope of the data, right? Like, what do you mean it applies to an email address? What do you mean it applies to an IP address? What do you mean it's IDFA from like the phone identifier, right? That's, what do you mean employee data, right? Because that is actually not covered now in any of the laws other than California. So that's a big leap because traditionally in the US before CCPA, the main privacy compliance pertained to data breach notification. And data breach notification in the US laws, unlike GDPR, does not apply. GDPR, it applies to all data, but then you do a like harm test. So if it's just email address, probably you don't need to notify unless it's a lot of email addresses, right? But like it applies to all the data. In the US, you need to notify only with respect to a small part of the data: driver's license, social security number, bank account information, like really sensitive things. So when you're dealing with like cookie information, the instinct, who cares about cookie information? So that's kind of the biggest leap. But after CCPA, there is a lot less difference because CPRA and the Colorado law are actually, they're not the same as GDPR, but from an upfront compliance perspective, they're very similar from like what the company needs to do in order to prepare.
When we talk about, for example, think about the Privacy Shield, it's down in 2020, right? July 2020. The Privacy Shield is over.
July. I think, what year is it? Is
2020.
I think 2020. Yeah, I think it was 2020 or 2021. Maybe it was, I don't know anymore. It was July definitely, but maybe 2020, maybe 2020. Sometime in the pandemic, basically.
Yes. So when this shield was broken, many companies in Europe have concerns and move data, come back to Europe because they don't see United States like a trustly place, a trustly country to make an international transfer. So how do you handling with this problem? Because in the end of the day, European personal data are treated in the United States, but you have many by contract rules or standard contract rules to stay in compliance with the GDPR requirements for international transfer. How do you handling with this? Because GDPR is very strictly with this international transfer, but United States don't talk specifically any law that I remember, but please, if I make wrong, tell me. I don't remember they mentioned about international transfer in the CCPRA, for example.
No, so not in the normal laws. I mean, you guys saw the bill in with respect to like, the information that's being transferred to China. So like things that have a national security issue, we're starting to see some stuff, but like not Europe. So the deal here, and that's another big problem and leap that companies that are needing either subject to GDPR or not, like just needing to deal with European counterparts have an issue with. So first of all, I think it's really interesting. So there is obviously the transfer impact assessment that you need to do for the cross-border transfers. That is, I have seen, different flavors of this. I know from European colleagues that this, especially like Germany, maybe Norway, Netherlands, right? Companies are doing TIAs. They're investing a lot of time in them. They are stopping transfers without them. I have seen, less of that with it's still like the wave. It's like, when you see a wave and then like you see it coming, but like so far it's just like a little bit and then it's not like, so we're still not seeing the full wave, and we'll see if we do, because if the, data privacy framework, materializes, maybe we won't. But right now it's like, it depends on the data. I'm seeing European providers that, are still speaking with the US, like European clients, still speaking with US providers, especially for less sensitive data, and basically trying to understand the risk and kind of, figuring it out. So with respect to that, I've seen different things. I've seen very formal TIAs. I have seen sort of semi-formal TIAs. I have seen a lot more, and I think this is warranted by the European decisions on this. I've seen a lot more treatment of understanding the data and what is the actual risk from the data, as opposed to the formal risk of the US law, both because, one, we already have a judgment that, it's not good. So like, what's the point of writing 30 pages of, okay, US law is not adequate? We kind of know that. But also because of the data privacy framework, where at least with respect to the surveillance part, which is the, I call it the hashtag NSA ate my cookies part, right? The part with the NSA surveillance, like you, the client in Europe, and you, the US provider, like neither of you can do anything about this. So the best that you can do is limit the data, pseudonymize the data, anonymize the data, have, controls like bring your own key, try to lock out, the servers, try to limit, the transfers, limit permissions, right? There are a lot of things that I've seen done to really look at the nature, the actual risk, and try and go from there. But I've seen, I know from colleagues that may or may not be enough. I've seen it not be enough, for certain places and for certain providers in Europe.
Do you see, I don't know, what do you think about the bind corporate rules and standard corporate rules, like a resource to create a common deal or a safe or security deal between Transfer Europe and United States? How do you see this resource? It's effective, it's not. You first create the PIA for international transfer, and then you think in a standard contract or standard contract clause, and then a bind, or you first think how do you think that it's work better for example, American company that thinking about treat European data, personal data?
So I think we're going to see more of this. I think here's the deal, right? Standard contractual clauses by themselves are not enough, at least per the CJEU case and the EDPB guidance, right? So you need supplemental measures. What are the supplemental measures? That is, we also have opinions from the EDPB that, contractual limitations and the technical and organizational measures like Article 32, right, are not sufficient in order to address the NSA ate my cookie problem, right? So you do need, first of all, I think even regardless of how the adequacy shakes out, I think that the commercial piece, right? The part where you need to understand the data, you need to take the steps and the things that you needed to do. Forget Shrems. Let's forget about Shrems 2 for a second, right? Difficult, but let's try. Even without Shrems, right? Or you still have the target company, let's say, or even like if there's no transfer, right? Like people are talking now about WhatsApp and Meta, like changing it such that the US company processes the EU data directly, right? So we already know per EDPB guidance, ICO, that this is not a transfer. It's a direct collection, right? So the transfer doesn't even apply. But what still does apply, you are still entrusting your data in the hands of another controller that may or may not be subject to GDPR. And if they are, or if they aren't, they need to guarantee that their processing of the data is compliant. So take the NSA aside, right? Because we're always talking about, oh, the NSA. Forget the NSA. Do we have data minimization? Do we have purpose limitation? Do we have the right legal basis? Did we do a DPIA? Do we have automated profiling? Do we know the downstream, right? I looked at something and like the subprocessor, like it was like going to like Oman and like China, right? Like those things are still going to be important, even if the US is adequate, because that's actual GDPR. So even if the US is adequate, actual GDPR still applies, right? So those things, and there have been decisions. There was a decision out of Denmark where they said, look, okay, there was a transfer problem, but actually you didn't do a DPIA, you didn't understand your processes, and your Article 24, obligations have not been complied with. So I think that this is the part that, I mean, right now, as long as we don't have adequacy, to the extent that you can, lock out the NSA via technical measures like encryption in use, bring your own key, stuff like, having, processing in Europe without access, etc. Whatever you can do, that's cool and that's important. But even after adequacy, now and later, you need to handle the other pieces. And now in the adequacy decision, we have the commercial principles. The commercial principles have not been amended from the original version. That part was very heavily called out by the EDPB as not okay. And now we'll see if the European Commission takes this back to the US and says, hey guys, we get that you made a huge progress here on the surveillance part, but like the commercial things, you need to like beef them up for GDPR. And so in either case, right, that part still needs to be done. So SECs are nice. In the SECs in Article 14, you are making an undertaking that nothing in the laws or the whatever destination country is prohibiting you from complying, right? So that's the NSA thing, but it's also how you process. So you locked out the NSA, but now you are, doing secondary processing for targeted advertising and you didn't get the right legal basis. Okay, that's a big problem, right? So that's what I would focus on.
I think that the legal base is a challenge to Brazil too, because first of all, people don't understand purpose and how to define this purpose and connect with the legal base. They define some crazy proposal and think, well, I think that this proposal, legal base, we can match this, but no. They make a big mess with propose and legal base. Yep. How do you see this?
So in this situation, we don't have a legal basis in the new laws. We do, however, have a lot of the Article 5 principles of GDPR otherwise. So we have data minimization, which means that we need to be able to prove necessity for the purpose, which is the same test as you need for necessary for contract and for legitimate interest under GDPR. So the necessity thing is there. The reasonable expectation of the consumer is there. The compatible purpose we also have, because under California and Colorado, if you process for a secondary purpose which is not compatible with the original purpose, and the tests are the same as the EDPB guidance, then you need consent, actual European consent for the secondary purpose. So that's one. And then the other is purpose specification is also required. And so the privacy disclosures that we are working on, they are not doing this whole, hey, here is stuff we collect, 20 bullets. Here is why we collected 20 bullets. Here is a legal basis, go figure it out, right? Like California and Colorado specifically require you to attach the processing to the purpose, so that when you are explaining this to a human being, they actually understand we are collecting your biometric identifiers in order to identify you, and we share it with this and we retain it for this, right? Like you need to understand for each thing what is actually happening. So in that regard, the end result is similar to GDPR in a lot of cases, maybe not in all of them, but at least in some.
I think that we can use a legal design to presentate this information to the data subject, right? I'm thinking about the privacy policies and the legal privacy notes, because sometimes I enter in some websites and you see, I don't know, something that's not so easy to understand. It's another point of the law, right? The information need to be clear, must to be clear to the data subject. You need see and understand, right? How you this challenge?
So that's complicated for two reasons. I mean, one, because, we still haven't seen enough of it and people are struggling with how to do it. And the other reason is that there is this disconnect between the amount of information that you need to present to people required by law, and trying to be concise and show it in an easy way, right? So it becomes, if you're trying to easily with icons, let's say people are saying icons or whatever, let's say you want to explain something with an icon, but there is 500 types of things that you're doing, right? Like you sign up for a newsletter, we use it for X, and then we actually have a pixel and we use that, and then we actually profile you and we have a segmentation and we share, there's a lot of stuff. So then even the icons, right? There is, you have a lot of information. So there will need to be some sort of balance between what you are required to present and how to do it in a sort of visually or easily understood way. And then the other piece, which, in Europe you're talking about, in the US now, the FTC is saying out loud, and so we will need to also deal with it, is the opposite of what I said, which is I just said, oh, we have 500 different types of data processes. How do we present it easily? And the answer by, the FTC is, well, then don't, right? It really isn't okay for you to dump these 500 things on a human being and expect them to not have consent fatigue, right? It's okay, you need to only do that which is necessary. You may not do some of the stuff, right, in order to front load the responsibility on the company. So I think we're starting to see more of it. I'm already seeing stuff with clients. Clients are asking me, oh, what can I do in order to do this biometrics processes? What kind of document do I need? And I'm like, okay, that's not the first question. The first question is, can you even do it? And the second question is, do you need consent? And the third question is, okay, what notice can I put on it, right? It's not the question under CCPA used to be, before it was amended, the question used to be, okay, what do I need to put in my notice to make this okay? And the question under CPRA is similar to GDPR, which is, can I even do this? Is this necessary? Is there a less invasive way of accomplishing this purpose, right? And then, okay, how do I, if I do believe that that's the case, how do I make it known to the people, and should it be optional?
About we have some points connected here: policy, legal base, international transfers, because all those information need be clear to the data subject, right? Now we have another point here that I consider it's very important, because in my opinion is the main point of the privacy laws, the data subject rights. Because when you choose correctly a legal base, you have some kind of rights. People in Brazil, we have this problem, because people said the data subject have the right to ask for deletion, erase the data. No.
Yep.
You cannot delete the data for any, just for the data subject asked to you. First of all, you need to understand the kind of data they propose and the legal base, because some legal base, the data subject don't have this right. They do not have this right. So this is, I don't know in your vision, but in Brazil it's a little difficult to explain this. We have a list of data subject rights, but it's not means that you can apply all these rights for the data subject, because it's depends of the legal base. This is a challenge in the United States, because you don't have legal base. But how do you handling with the rights? Because CPRA, I know you have rights. The CPRA, they establish the rights to the data subject, but the others, I don't know.
So I think, so we have the data subject or the individual rights, consumer rights, right? We have the right of access, the right to know. We have the right to correct, which is the same as in GDPR 2. We have the right to delete with some exceptions. We have the right to not be discriminated for exercising the right. Some laws also have the right to appeal, which is kind of similar to the to the supervisory authority thing in GDPR. And then you have the right, as you said, you have the right, and then you have the right to opt out, right? Opt out of sale or limit the use of sensitive information. So it ends up, it's not exactly the same as GDPR, but it's similar. So we don't have consent. In a lot of cases, we don't need an opt-in, but we do get an opt-out of a lot of things that GDPR gives you an opt-in of. For deletion, we do have, so for the right to access, we don't have that many exceptions. I mean, there is the excessive and fraudulent and vexatious, like the same as GDPR, right? If it's like somebody's sending 100 submissions, right? That's not a thing. And then trade secrets, right? You are not supposed to violate trade secrets. You're not supposed to violate third-party rights that are implicated by the data. And then deletion, there are more exceptions than GDPR, but they are similar. So for example, you have the right to delete, right? But let's say you apply and you want your HR data deleted. Well, you can't, because one, we are required to retain by law. Two, it is necessary for what we need to do. Like, I am an employee. I want you to delete my, whatever disciplinary hearing that I am subject to. Okay, well, you can't. We were in the middle of the investigation, right? I am a consumer and I want you to delete my bank information. Well, I can't ship the product, right? So there are a list of things, and there are one sort of catch-all, which is not similar to GDPR, which is, if it's aligned with the original purpose that the person intended, and like for internal use or something like that. So basically the way we do it is the sort of, kind of back of the envelope way to do it is basically sit with a client and say, look, here's the universe of data that you have. somebody files an access request or somebody files a deletion request. Which of this information do you have a problem deleting? And they're like, whoa, I can't do that because, it's legally required. And I can't do that because this, and I can't do that because they can sue me. So then we look and we try to match it up with a relevant exception. And then what we have to do, which is similar to GDPR, is if you get a deletion request and you are not fulfilling it completely, you need to tell the person, hey, you asked for us to delete everything. We did not delete 1, 2, and 3 because we are required to retain it by law, etc. So you need to explain it to them in the response.
When we talk about the last decision, the Europe Commission, they denied the new act or the new deal with United States for international transfer. Why do you think? Why they don't consider that don't have enough security measure, or I don't know why they don't accept this last deal?
Do you mean the Privacy Shield?
Yes, the new Privacy Shield.
The commission hasn't yet. The commission issued a draft decision. EDPB issued its opinion, and now the commission needs to think about it and decide. Right? The EDPB had a lot of reasons why it wasn't enough, and the reasons were twofold. Right? There is the surveillance NSA thing. And there's the commercial thing. The NSA thing, actually, if you look at the EDPB document, it was not, and I did a summary of this. If those of you that are interested can see in my LinkedIn profile, I summarized it. The surveillance piece was actually not that bad. It was a lot of, we realized that you guys did a lot of work. We realized that it's a really big improvement. There are things that Europe did not like enough. They said the proportionality that we have in there is not the same as proportionality that we know. There are some things that, there is a lot of flexibility for the president to change things. The court is, doesn't give you, they gives you this standard answer that we don't like. There are a few of those things, and some of them there might be a way to tweak, and some of them there might not be. I mean, the consensus is even the EDPB understands that this document, first of all, everybody understands that national security is a sensitive issue, and also they do understand that a lot of work has been done to improve it. The other piece is the data protection framework principles that were presented. And somebody posted a black line of those against Privacy Shield. And literally, it's exactly the same, except they changed the name, right?
Yes.
And in that situation, first of all, just on its face, it is difficult to argue, even if you represent companies. If a company says, hey, this is the way that I am ready, right? This is the way, here's my compliance as of 2015 or 2014 or whatever, pre-GDPR, right? And I changed nothing, but I'm still okay for GDPR. In most cases, from when we know what clients have done, that wouldn't really work. And the EDPB basically said, look, this is a document from pre-GDPR. And at the time, the Article 29 Working Party also said that it found a lot of things wrong with it. And we agree with all those. Go look there. But also, there are additional things that we disagree with. And that part had a lot of criticism, and mostly because one, the document didn't change. I think that visually is, was a problem for Europe to look at. And also because there are a lot of pieces where the document is, falls short of GDPR. Now, does it need to be identical to GDPR? No, because it needs to be essentially equivalent, right? But is it essentially equivalent? And there are a lot of things where the EDPB actually has a reasoned opinion of why not. And also, in parenthetical, there are a lot of things in there that are also less strict than FTC enforcement actions on US data. And that's federal. And there are definitely a lot of things there that are less strict than CPRA, Colorado, Virginia, etc. And so there, and this is for EU data, right? That deserves a higher standard because that's the requirement. So I think that part, I am hopeful that, my understanding, and there are bigger EU constitutional kind of law people that are more than me. But my understanding is that if generally speaking, historically, if the EDBB's concerns are addressed, and in this situation, my personal opinion is that the commercial piece is easier to address than this NSA at my cookie piece, then I think it is going to be more likely that it doesn't get stricken down by the European Court when, not if, because he already said that, when Max Schrems sues again, which he will, then if things are improved, it is maybe less likely for the court to strike it down again and have another Schrems 3.
Oh, the Schrems 3, this is the point. I visited Belgium in the last year, and I know I meet the Schrems in person. So it's interesting because I understand the concerns about the NSA question, the surveillance question, because when I visit the United States, when I arrive in the airport and stay in the with the police, you need pass the police. I don't need show or explain how much money I have, because they look at me and they know how much money I have in my account. So for me, it's a surprise. But okay, it's the United States. They know everything about you before you put your feet in the United States. So this is a surprise to me, but not too much. They look at me, okay, you can pass, but yeah, I know. You can, money enough, you can enter in the country. So this is for me, I understand is the law in the United States, but I understand that for a European citizen, or I don't know, some European Union citizen, they don't like this kind of privacy break, because they know how much you have in your bank account when you arrive in the country.
So this I don't know. See, this, I don't know the facts here, but the fact that national security agencies have a lot of information about us and use it, that we know, right? But the question is like this particular issue, right? It is not, this does not address law enforcement to law enforcement data sharing, right? Or official data sharing. It basically is with respect to the NSA through US based or subsidiaries of US based companies getting this information. So how they got the information from your Brazil bank account and whether or not your Brazilian bank had to cooperate, and is that an NSA and an NSA cookies issue, or is that why is my bank sharing this information, right? I think that's a different issue, right? And there are laws that require banks to do that, and they're sort of out of scope. So I think it's two different things, which is can the NSA, but not the NSA, GCHQ in the UK and the Canadian authority and the French authority, whatever, can they all get a lot of information about us and in a way that, we may feel is excessive? Maybe, but I don't know if that's not this particular issue, right? This particular issue pertains to how they get this in. And actually that's the point, because I asked an expert about it, and that's kind of the point. He basically said, why would the NSA need to do this and access it through get it from whatever the cloud service provider? They can just get it in a more direct way, which is sort of what your point proves.
I'm trying to say that when we talk the privacy perspective, we have different expectations. This it's a thing that happened and surprised me, but I know it's the American rules. We need respect. But I think that when it's just an example, but the NSA have much more information, so they can use in the ways that we cannot imagine. I think this is the concern, the European concerns, why they have, why they you will do with this.
But the thing is, right, and I don't disagree with that, but the thing is, and that's actually been, acknowledged by a lot of people in Europe, is that the European counterparts of the NSA can and do the same thing, except it's not in scope for GDPR, and therefore it's not subject to this issue, right? But it's not like the NSA didn't invent this, right? Like other national security agencies do similar things.
One question: do you have to handling some Brazilian adequacy company or some request? Your customers have some requests from Brazil to LGPD. Do you have need to analyze some kind of contract or SLA, service level agreement with Brazil, or some kind of document between United States customers and Brazilian customers? I don't know.
We've had a few situations where either it was like, a Brazilian customer, or actually we had situations where it was a Brazilian client of a US cloud provider. And we had to, assess, like address like the clauses and things like that, with respect to the transfer and by the transfer to the US and from the US with the Brazilian client.
But this client give it's easy to do this, or you think that Brazilian law? I think usually that Brazilian law is not so restricted than GDPR. GDPR it's more heavy when we talk about organizational measures and technical measures and data subject rights, but the Brazilian law it's more, I don't know, more
User friendly.
yeah, user friendly. Yes, more, yes, like user friendly. You don't have some specific duties. We have gaps when you need a specificate this duty. What the way you will show that you are in compliance with the Brazilian law. So they don't have many things in this case. They still work on the guidelines and have awareness. How do you think that United States, I don't know, just one opinion, do you think, or how do you think that United States can solve this problem? Do you think that a federal law can maybe one resource to take it easy, this, or make the path more easy to a new privacy shield, a new act that with the European Committee?
So I think it's not, it wouldn't be enough, right? Because if it were enough, then the answer from the EDPB would only concentrate on the commercial piece and say, hey, here is, because GDPR, right, itself, it carves out national security also. So a US federal law would also carve out national security, right? GDPR doesn't apply to the government institutions or whatever. They have their own directive, right, with the ADPS, and national security is like a different issue altogether. So I think if a federal law would have been sufficient, then the comments would all be, on the commercial piece and what needs done. Because there were a lot of comments on the surveillance part, then I think the surveillance part needs to be handled. But a federal law is going to do a couple of things. A federal law is going to make all of the commercial part easier, right? And companies won't need to like individually certify. They would be already doing it for themselves, for their clients, for everything. So I don't think that would it improve the likelihood? Sure, but is it enough in the absence of resolving this surveillance NSA piece? No, because everything's been revolving about the commercial, the surveillance NSA piece. I think a federal law would really be helpful for other things. I think it would make life easier for European and international companies doing business in the US, because right now it is just like, very complicated. But it would also make things easier for companies here to comply. And it would also improve the quality of protection that is provided to people in all of the states other than the 6, right, that don't have privacy laws, right? So right now, when we're looking at things, if you are a small company doing business in one state, right, or then you can look and say, oh, I am just in this state. This state doesn't have a privacy law yet, so I can do whatever. I can do this and this and the other thing, right? So that, puts people at a disadvantage. I do want to say one thing, which is important, that this part is also changing very fast. Why? Number one, because of the FTC enforcement. The FTC is building in a lot of protections that apply across the board that weren't there. The FTC issued enforcement actions requiring data minimization, requiring retention limitation, prohibiting dark patterns, now there's a rule on a one-click cancel, right, for consumer protection. They are looking at brokers. They are looking at pixels. They are looking at health information. They are looking at geolocation. So there's a lot of stuff where at least when I'm advising clients, I said, look, the FTC is looking at it and you could be in scope. The other thing that's happening is that there is a huge wave of litigation under state laws that are not like modern pixel and modern cookie laws, but they still are lawsuits on modern things. So we have lawsuits against Metapixel, using Metapixel, or using session replay and mouse click tracking and finger tracking in an app and recording chats and things like that. So a lot of stuff that is covered by GDPR is now being handled by this litigation. And so that is changing what companies are doing in a way that protects people more than they were before.
I remember one example that you said when the United States government, I'm not sure, but they prohibited the WeChat app and TikTok, I think, because they don't want the China have access the American personal data, the American citizens' personal data. So the most concern of American government is the China access.
So this is, China is sort of like the current thing, but I think the interesting thing, and I read a couple of analyses pieces about this, that these requirements and these bans, they're not really privacy centric. They're not really data protection centric. They are national security centric, and it's not that the fear isn't, oh, we're concerned with individuals' right to privacy because China, right? It's, we are concerned that a nation state that doesn't, share our values of democracy and et cetera, is going to use the personal information of Americans in order to do stuff, right, that compromises national security. And that could be, ransomware, phishing, social engineering. It could be like, swaying doing like fake news or content that affects elections. Like, I think those are the concerns. And the personal data here is a tool for the national security concern, as opposed to like the issue specifically being the use of the information because it harms each individual specifically in a data privacy way.
They use the American personal data against the American, right?
Exactly.
In the end of the day, against the American.
Right.
So
right.
In the end of the day, it's more about the national security than the privacy.
Yep.
Okay.
Yep.
You talk about the dark partners and the FTC. I read something about the dark partners that FTC create some rules, some requirements for this. And dark partners, in my mind, walk together with privacy by design, security by design, privacy by default. Do you see many policies about privacy by design? Because I have nightmares in Brazil because someone said that you need to create a policy. Privacy by design, it's a policy. I said, what the hell?
I think privacy by design being a policy I can see, because if you need, and it really depends on the size of the company, right? I mean, you need the end result to be correct. And for privacy by design, you need the company to consider privacy from the very beginning. If you are a really big company with a lot of business units and things, then you probably do need some sort of tool that says, hey, development team, you guys need to consult with legal or with whatever. Hey, marketing, like you need something. If it's like 3 people in a room, right, you can say, hey guys, do it, right? But if it's a really big company, I can see that. Dark patterns, I think, I don't know about policy for dark patterns, but dark patterns, I think, is interesting because California, Colorado, those states are talking about dark patterns specifically in the context of the opt-in and the opt-out. So not making the choices of the individual, either an opt-in or not opt-out, unnecessarily difficult through the design. The FTC is taking it a step further and talking about dark patterns generally in the consumer protection context. So it's not just data privacy at all. It is there a dark pattern that makes it difficult for you to opt out of a subscription that gives you more like, upsells? You need to click my son actually was playing some video game and came to me like really distraught because he normally like exit is like on the right and like buy is on the left or the other way around, and he pressed the wrong button and they charged him, and he was like really upset. It was like points in the game or something, but he was really upset. He was like, Mom, why did they put this in the wrong side? It's the wrong side, right? And so those are the things the FTC is actually looking at it from that. And there is actually besides the report that they issued about it, and besides the new rule that they're saying about, click to cancel, there is an FTC decision against Epic Games where it was $512 million total, but 200 and something of it, half of it ish, was about children's information, but the other half was about dark patterns. So the FTC is really taking this seriously, the dark patterns.
Well, we almost in the finish, but I have 2 more questions. One in the chat and one to like finalize or resume everything that we discussed here. International transfer, data subject, because in the end of the day, how do you show your compliance with a privacy by design policy? No, you need more than this. You need more than a contract or a standard contract or a policy in a paper or in a portal. You need to do more. So for me in Brazil, it's a big challenge to transform these statements in paper in process in process that really working inside the companies, because I'm not a lawyer, I'm a technical, so I'm cybersecurity. And I have one specialization in digital law, but it's just to understand how the lawyers think, to try understand the mindset. But in the end of the day, the challenge here for me is the sanctions, is the penalties, how we apply this, how we can make this enforcement more effective. For example, in Brazil, the national authority now publish your dosimetry, the sanctions, they create your act for the penalties, right? The how they will apply, calculate all penalties, all taxes, fees, and the sanctions. So GDPR have your own sanctions, your penalties, and I see some penalties in the United States, how you mentioned the Epic Games. How do you imagine these sanctions? Can you compare the sanctions, the amount, the enforcement? Do you think that when the authority apply a high penalty, company really will change the process?
So I think we're seeing a couple of things. First of all, in sheer numbers, I think we are seeing a lot of much of heavy duty fines in the US, even more than in the EU, by way of either the FTC enforcement or litigation. And we have like BIPA. There was a $248 million fine. There was an $18 million case in Massachusetts, right? And we've obviously seen the FTC cases, right? BetterHelp just got almost $8 million. GoodRx, $2 million, right? Epic Games, $512 million. So we're seeing a lot of fines. I think we're seeing a couple of things. Number one, the fines are serious. Number two, litigation is serious, right? So if you mess up your data breach, you are going to be sued, and you're going to have class action lawsuits, and they are very expensive. So that's number two. Number three, we are starting to see by the FTC, and then when California starts enforcing, we'll see this in California too, there are sanctions which are not a fine. They are an injunction against using the data. You need to delete the data that you collected without permission. They did that with Weight Watchers. They did this with Everalbum. So that is a big deal, because forget the fine. A lot of companies are big enough to be okay with the fine, but if they can't use the data, that's a big deal. On the other hand, we're seeing something else which is interesting, and we've seen it in Europe too. Keneal is doing it. Noib, Max Schrems's Noib is doing it. They have begun, for example, cookie sweeps, right? And they go to companies, they're like, guys, you're not compliant. If you don't get compliant within 30 days, 60 days, whatever, we're going to file a complaint. And both Noib in their report and Keneal in its report are saying more than 80% of companies become compliant without any litigation. In California, until now, there was a mandatory, and also in Virginia still now, and in Colorado when it starts, there is a mandatory 30-day cure from the enforcement. So the authority needs to come and tell you, hey, you are not compliant. You have 30 days to comply. And in the majority of cases, there have been reports by the California Attorney General with all of the cases where it didn't end up in litigation because the company just complied. And so that's something else that's really interesting, is that you can use sort of the, warning or threat of compliance or litigation as a way to get companies compliant without a public name and shame, without the fines, without the expenses of litigation. So I think we're seeing all three of those things.
I think that in Brazil, the authority not apply no fine at now. So they are very generous at now. No act like an authority. So it's my critical about the Brazilian authority. They have I don't know. Maybe it's more careful, or they afraid to apply a fine. I don't know. I'm not sure. But when we look to the authorities outside of Brazil, in Europe, United States, you apply, you make the enforcement, because what is the KPI, the key process indicator of authority to you? For example, the fines.
I mean, I think that and this is like, my friends from the regulators in Europe too. I think the goal isn't how much money can you make from fines. The goal is how compliant are companies becoming? How are you changing behavior? So I think whatever is the more effective in changing behavior, the better. I mean, it's the same as I see this with my kids, right? Like, okay, no iPad for 2 days. Okay, did this change the behavior? No, it didn't help. So I don't care about that. I think the most effective thing, and we'll see what works more, is, the thing that works is you are changing behavior and improving protection of rights. That's the goal. And it depends what's the best way to get there, right? Is it a threat? Is it like an injunction? Is it, what is it?
Yes, I think this is a challenge when we talk about authority, how we can measure your effectiveness, how much effectiveness it's authority. We can try, I don't know, maybe if the United States data privacy framework consider KPI for the authorities, you can include this. One KPI for authorities: number of fines, amount of fines, number of companies that must be or should be reincident in the fine. I don't know. Maybe this we can. I think I see this like a way to measure the authority job or your effectiveness. So, in the end, do you have some advice for the person that listen us? This video will be available in our YouTube channel. It's storage in our YouTube channel, so many persons can access after our webinar ending, but they will available for the next time, or for the people that cannot follow us in the real time. So, but what is your advice for who want to work with data privacy regulations in the United States and Europe, make this intersection? What do you advise for this person?
I mean, I think the point is that the U.S. Even though the U.S. does not have a federal privacy law, there are a lot of laws. There is a lot of enforcement. It is very complex. It is super developing very fast, and there are a lot of nuances. And I think really the sort of like simplistic advice that I can say is that if you have clients that or you are part of companies that are looking to do business in the US, I think you need to talk to, privacy counsel. You need somebody who is a privacy specialist that understands these laws, preferably also understands, the European or Brazilian framework, and sort of can kind of translate this a little bit and see what you've already done and how you can repurpose it. But really, I think it is, and when I speak with Europeans, this is often the perception of like, oh, we're compliant with GDPR, so we're good, right? And it's not true. There is a lot of stuff that is not exactly the same. There are other things that you need to be thinking about. And so that really is really the bottom line, is that it's really a complicated, fast changing area with nuances, and it would be really better if you had like a US privacy expert that would help you through it, rather than try to kind of assume that if you're good on LGPD, then you're good with the US, because it's not really true.
It's not the same thing. Have many particular, many nuance.
Yep.
Like, I read about the BIPA and HIPAA because I have clients in Brazil make a business with the United States. So these laws to me make more sense. It's more common for me, but the FTC is new. I'm read about, but not too much, or not enough. So because this, I ask your advice for, because have many persons and try understand this scenario, the world scenario about privacy laws. So I can now we will finish our transmission. Please, you have your words. You can create or do your finish. You can have some words if you say. First of all, I need thank you for your time. Thank you for accept our invite. I know that you are a very busy woman, and the people here have many doubts about these specific points: international transfers, data subject, legal basis, GDPR, American. They think that no, American don't have law. Yes, American have law, but it's a little different. But they have, and it's very hard to understand. It's not so easy, but they have. So I appreciate your time. In the name of our 4 communities, IBRASPD, WOMC, LATAM, FEMIT, and Cybersecurity Girls, our sincere thanks for your presence here this night, for donate to us your time, for give to us your time. And I need thanks the marketing team, the cybersecurity girls, Katarina and Isis, Gabriela and the WOMC, and Carlos and Renata is here in the chat, my colleagues, the IBRASPD board members. So accept our very, 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 we appreciate your time. So please, your words.
Thank you. Yeah, no, I'm happy to be here. I'm happy to, support women's communities and in this area and privacy and security. I think that, that's kind of the only way to promote women in these areas, is to kind of, just be a woman in this area and kind of, set, I guess, an example by doing. And so hopefully, I did that. And yeah, I would be happy to hear from you. Feel free to connect with me on LinkedIn. And if you have questions or if you have feedback, I would be happy to connect with you. Thank you.
Thank you very much. Pessoal, a nossa live chegou ao fim aqui. Eu agradeci a Odia. Quem quiser mandar pergunta depois, a gente manda para ela, tá? Boa noite aí para vocês que acompanharam a gente pelo canal. O vídeo vai ficar gravado. Quem quiser pode acessar depois. Tentem achar a versão do YouTube com legendas. Eu não consegui habilitar. Muito obrigada para todo mundo que acompanhou a gente. Quem não acompanhou ao vivo online pode acompanhar depois, porque vai ficar gravado no nosso canal. Hi, guys. It's finished. So thank you very much. Good night. We will goodbye here, but I hope that in future we have more meetings, more webinars like this to share with more women in privacy community. It's a challenge. Thank you.
Thank you. Thank you.